Annex, may we have Castro, Fabiola Castro, second on page 17, Judge.
Got it.
In cause number 2023-0D00035, State of Texas versus Fabiola Ramirez Castro. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Jose Trujillo on behalf of Ms. Castro, we are ready, Your Honor.
All right. I'm showing we're set for a bond hearing today, and so I will take that is your motion, Mr. Trouchet. Do you want to go first?
Yes, Your Honor.
Will you start off by telling me what the current amount is?
Your Honor, I should, let me look here.
Judge, I'd also like to mention that there's another case that she has pending, but is not on the docket today.
Or what is that?
A burglary habitation, 2023-0D00538.
Okay, did you know about that? Did you know about that one, Mr. Trouchet?
I do, Your Honor. I represent her on all her cases. We had a bond hearing on that. I think she has a PR bond on that, does she not, at this point? Well, she did at one point, and then
yes, but it was revoked. It's been revoked, I think, twice.
okay. Well, then in that case, Your Honor, we of course we'd like to get a bond on everything. Let me let the court know, Your Honor, that I've spoken to my client at some length, and also to her brother, who is currently has custody of her children. There's no question that my client needs some supervision. The problem we have right now, Judge, is we don't have a setting in this court until almost a month from now. We have a setting coming up on March the 23rd, and my client has been in jail ever since. I was looking at she finally got on portal on this newest case, and I was looking at the report, and there is at first there was a report that she had thrown a bottle of liquor at the attendant there, and that's what the attendant reported. Later on, they got the video, and it showed that she did not throw the bottle, but then the lady, the attendant, changed her story and said that they took a swing at her head with a bottle of tequila. And that at that point, basically, Your Honor, we believe this is a shoplifting situation gone wrong, but we don't believe, Your Honor, that she poses a threat or anything else like that. What we'd like to do, Your Honor, and I've spoken to my client about this, is that to place her under the mental health protocol, have her report. First of all, we're asking for a PR bond because she has no money. She does have a place to live, and she gave me the address, and I promptly misplaced it somewhere, but she's here, so she'll be able to give us that. And then, Your Honor, that she is to report to the mental health people and start as long as these cases are pending. So that's our request today, Your Honor.
Okay, so this is the thing. I still don't know what her bond amount is right now. That's my first question. My second question is, did Ms. Elizalde realize that the bond hearing was going to be on both cases? There's only one that made the docket. I'm trying to get is it 2023 or 2022 on the new burglary of a hab, Ms. Elizalde?
That one's actually older. It predates this one, and it's 2023. And there was a bond hearing order. Well, there was an order denying PR bond on February 7th, 2023.
That's correct.
For some reason, go ahead.
I mean, I'm not sure that I read these correctly, but it says original bond is no bond. That's what I don't think she has a bond on that.
Yeah, I'm trying to find it by case information, but let me do by last name.
Oh, and there's another problem, Judge, that keeps happening in this case. Her name is Fabiola, And half of the cases are under B for like burro, and the other one are V for Victor. But she tells me that her real name is Fabiola, is with a V with the Victor.
Well, I only have one that is technically showing on my docket, and that one has B as in boy. Are you saying she's V as in Victor?
That's her correct, and in fact, the setting. I
Okay.
see that the setting is under B for boy, as the court has indicated. So I guess we'll go with that, Your Honor, just to make sure. For a while, it was causing some problems in the jail mag, but I'm hoping that has been resolved.
Both
Right.
of them have B as in boy.
Okay.
Yeah.
Then we'll go with that, Your Honor.
Okay, well, and I'm just on the 538. The 538 is set for arraignment on March 2nd. So you'll actually, so Ms. Hernandez, if you'll go ahead and put this one on the 3-2 docket also, the 35, the 000035, if you'll put that one on the same docket as 3-2.
Yes, ma'am.
And then let me see where we are on whether or not I can say the state did get notice. Okay, so this is the problem. Right now, I'm not showing a motion to reduce bond filed on the 538. So Ms. Elizalde, are you waiving your notice on that one?
Judge, I'll waive notice.
Okay, so then with that being said, I still need the amounts.
Okay, that I'm gonna need help with because I just see.
It's
no.
okay. Let me see if I can get either.
I'll get my secretary working on it also, Your Honor.
No,
Just-
let me get Miss Catherine. Miss Catherine, let me figure out where I can find the bond.
Yes, Judge, burglary is no bond.
No bond. Okay,
The ag robbery is 12,500.
12,500.
That is correct, Judge.
Okay. All right. All right, so Ms. Elizalde, go ahead and give me what you feel are the facts that I need to know in not only determining the setting of bond, but whether or not I'm going to reduce the ag robbery bond.
Okay, Judge, as to the ag robbery, I did want to point out that the way that Mr. Troche posed the facts was that my complaining witness changed her story. That's in fact not how it was. The video did show that the action of the defendant was more like swinging, or they swung the bottle, but we have a witness who also saw that, and she was found with all the stuff that was stolen. So she picked up this new aggravated robbery. Another thing that I would like the court to keep in mind is she's got a lot, P files. She has a criminal mischief that has been accepted, but it has yet to be filed, a VPL that has been accepted, but yet to be filed, a possession that has been accepted, yet to be filed, and a resisting that hasn't been screened yet. And the other thing I would like for you to know, Judge, is when PR bond was denied on the burglary of habitation, I believe this is why. On the PR bond, a VN was submitted because she picked up a possession in a VPO. And also because she failed to report. And she was placed back on PR bond, and another VN was submitted because she picked up the aggravated robbery 2 days later. I think this particular defendant has demonstrated to this court that they are at flight risk, that they will not show up, that they're not reporting. And so we would oppose reducing the bond on the aggravated robbery, and would ask the court to set a bond on the no bond one that accurately reflects the fact that this individual was not reporting. And the 2 cases before the court are very concerning. I have all the facts in case you have any questions.
Okay, so let me have the location as to where the ag robbery occurred with the bottle. Is it a bar or is it a store?
A liquor store.
Okay, so it was an actual, so my victim is a
Worker, an employee of the store.
trying to turn, okay, gotcha. Now, what's my story on the burglary of a hab? A little bit, please.
Yes, officers dispatched in reference to the burglary of habitation. The CW provided surveillance video showing the defendant damaging a wooden front door and entered his residence. CW is brother. She took water and a Coke. The defendant later spotted walking and officers recognized her from a previous encounter. She stated that she went up to the door and heard noises. She was afraid that something would happen to CW and their mother. They stated someone was doing witchcraft on her. She broke the door to make sure everything was okay. She took a water and Coke and she demonstrated to officers how she kicked the door.
All right. On the ag robbery, is there a PR component at all on the ag robbery? If it might be Catherine who answers me on that one. Let me go back to Odyssey and see if I find it on Odyssey.
No, Judge, there isn't.
Okay. All right, Mr. Trochet, your client concerns me because there is a lot of cases. All right. And I'll be honest, the 12,500 on the ag robbery was more generous than what I thought it was going to be. All right. But I am going to add a PR component to it. I'm not going to reduce it. I'm adding $1,000 PR component because I want to have no further contact with the CW, no further, not going within 200 yards of the distance. And if she does post bond, I want monthly reporting, no consumption of controlled substances. Give me 1 second. Let me make sure I have everything covered from the court. Give me 1 second. Okay, so going back, the ag robbery will stay at 12,500 cash surety. I'm adding $1,000 PR bond to that to report monthly, curfew from 6 to 6, not come within 200 feet of the victim or the location, not leave El Paso without permission, give a sample upon request, not commit any new offenses, not possess weapons or ammo, and to be screened by Takumi. All right. So I'm adding a PR bond component to that, Mr. Trochet, in case she does get out.
Yep.
But I'm not going to be reducing the 12,500. Now, as for the burglary of Ahab, I do believe she is entitled to a bond. If you'll give me a minute, I want to look over her criminal history just a little bit more. Give me a second.
And Your Honor, I think the prosecutor said it correctly, but the burglary of Ahab is her brother's house where her children are staying. So I just want to make sure that.
Right, but she's on no bond for that, so you need a number right now.
Yes, Your Honor, I do. Thank you.
Yeah, so that's what I'm going to try to give you, if you'll give me a second. I
Thank
do
you very
realize
much.
it's a CW, but what happened was that ag robbery was much lower than what I thought you were going to tell me. A whole lot lower. It's a first degree. And so the 12,500 surprised me. So give me a second on the burglary of Ahab.
Yes, ma'am.
All right, for the bond on the burglary of Ahab, I'm gonna go with 25,000 on the burglary of Ahab with a 5,000 PR component and the exact duplicate conditions that I stated for the PR bond. Reporting once a month, curfew from 6 to 6. On this one, I don't need the 200 feet because since it's the brother, you're telling me that he is supportive of her.
Yes, he is.
So
Right.
on the burglary of Ahab, I am not putting the 200 feet, not leave El Paso, sample upon request, not commit a new offense, shall report to PR bond if they move, which will be the same condition added to that other one. I did not say that one before. Not possess weapon or ammo, and to be screened by Takumi. And so that one will be 25,000 and a 5 PR. Okay,
I got it, Your Honor. Thank you.
thank you. I know it wasn't what you would have wanted, Mr. Trochet, but at the same time, her history is concerning me. Or her
Okay.
current condition is concerning me.
I understand. And I'll go and visit her very soon. I just wanted
right.
to do that.
Meanwhile, I have moved you up. Both of these should be set on March 2nd. All right.
Thank you, Your Honor. Appreciate it.
Thank you, Mr. Troche. All right, Mr. Marufo, who's next? We're adjourned on this matter.
Thank you, Your Honor.
Page 16, Judge. Annex, may we have Acosta, Josue Acosta? In cause number 2022-0D0-0350 and 2022-0D0-1194 and 2022-0D0-00066 State of Texas versus Josue Acosta. Announcement of council, please.
Preston Munson for the stage ready, Your Honor.
Christina Montes on behalf of Mr. Acosta, Your Honor, ready to proceed.
All right, Ms. Montes, do you see your client on the Zoom camera today?
I do, Your Honor.
All right, Mr. Acosta, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Your Honor.
All right, you may lower your right hand. Mr. Acosta, I need to start off by asking, are you okay waiving an in-person hearing for this plea of guilty and proceeding on the Zoom teleconference?
I'm okay with that.
All right, so then with that being said, please state your name, date of birth, and whether or not you are a U.S. citizen for the record.
Jose Emilio Acosta, 03/04/1995, and yes, I'm a U.S. citizen.
All right. You are currently charged with 3 offenses. The one on 1194 is possession of a controlled substance, penalty group 2, under 4 grams, over 4 grams, under 400 grams, which is a second degree, which is confinement not to exceed 20 years, but no less than 2 years. And on 2022 0D00350, you're charged with a 3rd degree unlawful possession of a firearm by a felon and a 2nd degree ag assault with a deadly weapon. The charge for the 3rd is not less than 2, not more than 10. And the 2nd is not less than 2, not more than 20, with a fine of 10,000 for both. Do you understand the charges?
Yes, ma'am, I do.
All right. You understand you have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, and a right to call witnesses on your behalf or in your defense.
Yes, ma'am, I do.
All right. Ms. Montes, have you had more than 10 days to prepare for the defense in this case?
I have, Your Honor.
All right. Mr. Acosta, I have what's been marked as State's Exhibit 1, which are the plea papers in this said cause number. Is this your signature on, did you sign these packets?
Yes, I do remember saying.
Okay. Did you read and understand the plea papers?
Yes, I understand.
All right. Ms. Montes, did you explain the plea papers to your client, and do you believe he has understood the admonishments, the rights, and the consequences of giving up these rights by entering a plea in these cases?
I did, Your Honor, and I do.
All right. Mr. Acosta, are you satisfied with your attorney's representation of you in this case?
Yes, very.
All right. And Ms. Montes, do you believe your client is presently competent to enter into this plea?
I do, Your Honor.
All right. Mr. Acosta, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
No, never.
Okay. Based on your testimony, your attorney's representation, and my observation, I'm going to find that you are competent to enter this plea. You previously stated you are a U.S. citizen, and while I do believe you, I need you to understand if for some reason you are not, a plea of guilty and a finding of guilt may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, I understand.
All right. To the charges against you, Mr. Acosta, what is your plea?
So which ones am I signing for today? That's
Okay.
the- I don't understand.
Okay, my understanding is you signed for the possession of controlled substance penalty group 2 under over 4 under 400, and that you signed for the ag assault and the unlawful possession of firearm by felon. My understanding, not to get ahead of me, but my understanding is there's going to be a case that is being dismissed.
Okay, so the one that's getting dismissed is the ag assault, right?
Ms. Montes?
Yes, that's correct, Your Honor.
No, the one that's being dismissed is the assault, family violence, impeding breath.
Yes.
Not the ag assault that's being dismissed, Mr.
The ag
Acosta?
assault and the unlawful possession of a firearm is being pled to.
Mr. Acosta, did you understand the charges that are before me that you are scheduled to plead to?
Well, that's why I'm confused because I thought I was gonna sign for the family violence and I thought the ag assault was gonna get dismissed.
Okay. All right. Ms. Montes?
Judge, I went over the paperwork with Mr. Acosta, and I just want to make sure that we're all on the same page on the one that is being dismissed. Mr. Munson, just to confirm, can you confirm for me the last digits of the case that's being dismissed?
The last digits that are being dismissed is 00066.
That's the one I have here. Yes, Judge, and those are the ones that I went over with Mr. Acosta. Obviously, if he's not understanding the one that's getting dismissed and the one he's pleading to, I would need to go over it with him. And again, I don't want him to plead to anything he's not understanding.
All right, so let me do this. Let me go ahead and Mr. Marujo, will you go ahead and send them can you send them to a breakout room while they're in the jail? No, because what happens is then it limits my microphone there at the jail, correct?
I can put him in a breakout room, Judge, but
Then I lose the microphone for the other people on
Correct.
yeah.
correct, if they wanna wait till the end of when we get done with everybody, Judge, I can put him in a breakout room at that time.
Ms. Montes, I can't lose my microphone with the jail.
Of course, no, Judge, I have no problem waiting until the pleas are done and then I can do that.
All right, let's do that then. Okay, Mr. Acosta, I'm gonna go ahead and have you sit down for right now. I'm gonna proceed with the rest of the docket. And at the end, I'll put you in a breakout room where you can speak with Ms. Montes. I can't put you in a breakout room right now. You'll end up taking up my microphone and my camera, and I need it for the rest of the people there, okay? So go ahead and have a seat. We're not sending you back. We're gonna try to take care of this today, but I need you to wait, okay?
Appreciate you.
Thank you. All right, Mr. Marufo, who's next?
Top of page 17, Judge. Annex, when we have Bywater, Killian,
Yes, Your Honor. Bywater? Bywater. Yellow lines.
in cause number 2021-0D02344, State of Texas versus Killian Ray Bywater. Now, Councilman of Council, please.
Okay, Louis, so for the state is ready.
Brock Benjamin on behalf of Ms. Bywater, and we filed a continuance several weeks ago, Your Honor, and my only issue there is that I had requested the 17th and the 24th, and I had a federal court set me on that second one, so I just need to amend that in the motion.
Okay, so then are you free on the 17th of March then?
I am, Your Honor. I'd like to get this tried, and spring break has disappeared.
Okay, I mean, I can give you more time, but it's up to you.
He's in custody, Your Honor. I'd like to.
I know, he's been in custody close to 10 months from what I can tell.
Right.
Right. Okay, so then let me go ahead and put you as a special setting for March
Thank you.
17th. It's in a little bit less than a month. Ms. Elizalde, will you be ready for that special setting?
Yes, Judge. I conferred with the CWs before I responded.
All right.
I think
right.
she filed an actual notice, Your Honor, but so I think that date works for all of us.
Okay, so Mr. Benjamin, are you wanting to go forward with the bond hearing, or you just needed the setting?
Your Honor, I would
Oh,
love
you
to go.
weren't,
for the
you
bond
weren't
hearing.
set for a bond hearing. I'm sorry.
I'm not set for a bond hearing, but he's been detained for 10 months on a $10,000 bond, so.
But he's coming up for trial in less than 1 month. So you got your special setting.
Thank you.
March 17th, 2023. All right, Mr. Benjamin, anything else on your matter right now?
That's it. And I'll come out and see you probably Monday or so, Kelly.
All right, we're adjourned on this matter then.
Thank you, Your Honor.
Thank you,
Thank you.
Mr. Benjamin. Take care. Mr. Marufo, who's next?
Bottom of page 16, Judge. And next, may we have David Aguilar.
Yes, sir. Thank you, Lord David.
In cause number 2023-0D00319, State of Texas versus David Aguilar. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alyssa Nava on behalf of Mr. Aguilar, Your Honor, and we're ready to proceed.
All right, Ms. Nava, it is your motion, so why don't you go first? But if you can tell me the bond amount, that would be really wonderful.
It is currently set at $100,000 cash surety.
All right, thank you for that. Go ahead and proceed.
Yes, Your Honor. My client is a United States citizen. He has been employed for the past 13 years with Quality Splicers as a lineman. If he were to be released, he would still have his job with his employer. He does have a place to live. He does rent a home, a duplex with his mother. He is the one that is providing financially for both himself and his mother. He was born here in El Paso and all of his connections are here in El Paso. The original PR bond was revoked. So he was released in December and then didn't report at all. It was his understanding that the cases had been dropped. Now, that was a complete misunderstanding. He did pick up 2 additional offenses. All of these are non-violent offenses. And if he were to be released again on a PR bond, he now knows that he would need to comply. I think that he does also have past history of compliance on PR bond when he was accused before of an unauthorized use of a vehicle. He does have a history or a family history when it comes to dementia and Alzheimer. And as he's gotten a little bit older, he does have some issues with his memory. However, now with the assistance of counsel, I think that he's going to be able to check in as required. He will stay away from the place that the accusation stems from. He has a place to live and he has a way to contribute to the community through his job. His siblings are here. And he cannot afford any bond, and we respectfully ask for a for a PR bond.
All right, Ms. Elizalde.
Judge, so the facts that I have are the officer's dispatch of reference to a suspicious subject. The neighbor stated the defendant tried to enter the residence and was asked to leave. He then saw the defendant to the CW.
Can you slow down a little bit, please?
Sure.
Okay.
Can I start where I said he then saw?
Actually, when you're saying he's entering the residence, are you covering the criminal trespass, criminal mischief? Is that what you're covering?
No, I'm covering the felony failure. The felony
Fraudulent use?
fraudulent, yes. So I'll explain.
Okay, go ahead and explain it then.
Okay, so officers were dispatched in reference to a suspicious subject. The witness, who is a neighbor, stated that the defendant tried to enter his residence and was asked to leave. He then saw the defendant go to the CW's house and damage the mailbox. He saw the defendant take mail. Defendant told officers the property belonged to him and that he tried to get his mail with his key. Officers asked to try to open the mailbox with the key. It did not fit. CW stated property had been vacant for years. Defendant provided mail he took to the officers with different names and addresses for a total of 9, which is the basis for this charge. Judge, he has quite a bit of history, not only here, but he has in New Mexico, battery against a household member. I'm unsure what the dispo is on that. Concealing identity in 02, not sure what the dispo is on that. Warrant for failure to appear in 02, unknown dispo. And then we have Arizona.
I saw that he's gotten some felony convictions in Arizona and did some time in the state pen. So let me ask you something.
Sure.
The charges that he had the information from the mail, is that what I'm understanding where is alleged to have gotten the information from?
Yes, names and addresses in the mail he had separated.
Okay, and so these pieces of mail were on his possession.
Correct.
Okay, thank you. I was trying to get that cleared. All right, and who would he live with, Ms. Nava, with his mother?
Yes, Your Honor.
And then how many siblings did you say he had in town?
So he has, I believe it's his 2 brothers, Your Honor. I'm sorry, 3 brothers. He has 3 brothers.
Okay, 3 brothers. Okay, so my concern is that he was given a PR bond in December and he failed to report, and then he picked up the 2 misdemeanors. Those 2 misdemeanors are criminal trespass and a criminal mischief. So Ms. Elizalde, you're saying that that criminal trespass and that criminal mischief is not what happened to the mailbox and not what happened on with the neighbor's property?
Correct. Those are different allegations.
Yes.
Okay, and then where did the criminal trespass and the criminal mischief occur that were the misdemeanors? In the same neighborhood?
That I would have to. I'm gonna go back into the date. Just a moment, Your Honor. I don't have the information on those misdemeanors.
Okay.
Okay, so the criminal mischief and the criminal trespass were fairly recent. The offense date happened January 23rd of 2023. The fraud, which is the bond, the basis for the bond today is 12/26. So they're not related in time. And then I'm gonna go ahead and look at the addresses.
This was it was over on Carolina Street.
Okay,
I have. Oh, no, yes, you're right. Mhm.
and is Carolina Street where he was living with the mom, Ms. Nava?
No, Your Honor, he lives on
General, is that the address?
Hula Vista.
On where?
Hula Vista.
Hula Vista, Chula Vista, Hula Vista.
He spelled it to me as Kula, but it might be Trula, but let me.
That's fine, that's fine. Okay, so this is the thing. Mr. Aguilar's criminal history concerns me quite a bit, but I also recognize the fact that $100,000 bond for a 3rd degree is up there. So I have to give a number, but I'm not trying to make it easy either, Ms. Nava, okay? So what I'm gonna go ahead and do is I'm doing a 60,000 cash surety and I'm adding a 40,000 PR, okay?
Okay.
As that 40,000 PR, I want him to report twice a month. I want curfew from 6 to 6. He is not to come in within 200 feet of both areas. The one that is the mail. Is that going to be his mother's address?
No, neither of them are his home address.
Okay, so Ms. Elizalde, if you can go ahead and give Ms. Marisa the 2 addresses that he needs to stay away from. He must give a sample upon request, must not leave El Paso without permission, must not commit any new offenses, must not move without letting us know, must not possess weapons. And did you mention that you thought he might have some mental health issues, Ms. Nava?
So that there may be some signs that he doesn't necessarily remember, and he does have a history in his family of Alzheimer's or dementia.
So let me go ahead and get him screened by Takumi. Let's start that process and figure out where we're at. Mr. Aguilar,
Yes,
I
ma'am.
have lowered the bond and added PR components to keep an eye on you. Understand that you must do what they instruct you to do.
Yes,
If
ma'am.
you do not, we will revoke the PR bond and you will be back in jail.
Yes, ma'am.
Okay? I am covering for Judge Pettis, and I am hoping that I am doing as she would do if she were seated here.
Yes,
But it is her that you ignored on that first PR bond in December. Okay?
Yes, ma'am. That was my mistake. I understood something else,
All right.
but I won't.
Do not ignore me, and thus do not ignore her through me. Do you
Yes, ma'am.
understand?
Yes, Your Honor, I won't.
All right, Mr. Aguilar. If you get out, you will have these conditions and you must abide by them.
Okay.
All right? All right, Ms. Nava.
Thank you.
Thank
you.
you.
Judge, the addresses are to Ms. Nieto, correct?
Yes, to Ms. Nieto to be put on the PR bond.
Okay, I'm gonna email those over.
Thank you so much, Ms. Elizalde. Mr. Marufo, Ms. Nava, if you're free, if you're done, you are free to go. Oh, she already left. Okay, good. Mr. Marufo, who is next?
Page 17, Judge.
Okay,
And next, may we have Estrada, Seth Estrada.
Who?
In cause number 2022-0D05486, State of Texas versus Seth Fabian Estrada. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Anthony Gonzalez on behalf of Mr. Estrada, ready, Judge.
all right. Mr. Gonzalez, this is your motion, so I let you go first, but let me ask you, what is the bond amount, please?
15,000, 15,000
Okay,
on a 2-count case.
okay. All right, go ahead.
All right, Judge, Seth was previously living out of town. I think it was Alaska first and then Colorado, where he met a woman, he married her. And then recently she decided that she didn't want him anymore. So she was divorcing him, or is divorcing him. Caused him to get depressed. He came to El Paso and he started to stay with his mom and his sister. And while he was there was an altercation or some issue. The cops were called out. And as a result, we are here today on the assault on a peace officer in the possession of a controlled substance. Mom and sister lived at a particular address, and they said, well, we're not going to help you out anymore, Seth. So grandma kind of stepped in. Her name is Julia Estrada. And Julia lives at a separate address than mom and sister, which is 14629 ESCOLER Drive in Horizon City. Seth is unemployed at present. He's been in jail since right around Thanksgiving, 11/24/22. He has no money, and neither does grandma. Judge, the case that on the peace officer has many videos. There are several videos that were taken by the police officers, their body cams and other things. And then, of course, Seth's mother and sister have their own videos. The allegation is that my client took Officer Steve Herrera to the ground by pulling or throwing him to the ground. I've looked at those videos. I don't see any evidence of that. I may see Seth kind of tightening up and not allowing him and the 9 other officers that were trying to put his hands behind his back. I don't think that case is going to work. The possession case is a little bit better for the state. But $15,000, I think, is a bit much. My client, as a result of this divorce he's going through, has been going through a deep depression. And I'm going to ask the court to consider a complete PR bond.
All right, Ms. Elizalde?
Judge, the state would oppose a PR bond based on the defendant's record and the nature and circumstances of the case as well. A brief summary of the facts. Officers were dispatched in reference to a verbal family violence call. Comments on the call, the defendant acting aggressively, making threats, and high on meth. The defendant took a fighting stance when officers got there. They were able to calm him down and asked if they could pat him down for weapons. The defendant agreed. Officers asked him to put his hands up, and as he was grabbing his left arm, he quickly brushed it away and began to face the officer. He then lunged at the officer and attempted to throw him to the ground. Officer attempted to throw the defendant to the ground. Defendant grabbed onto him and they fell together, causing injuries to his knee. Officer then punched the defendant who continued to resist. Incident to arrest, they found multiple clear small plastic baggies with a crystal-like rock substance that tested positive for meth from a field test. His record, I have assault on a public servant. So the same charge that in 2013 reduced to a misdemeanor assault bodily injury in 14. An AFV, assault family violence in 2015, a resisting in 2013, and evading with the vehicle that was dismissed in 2018, a criminal mischief in 2018 that was deferred, an assault family violence again in 2018 that was deferred, criminal trespass in 21, and another evading dismissed in 2021. He has out-of-state record, Your Honor. I will caution, this is from the rap sheet. I'm not sure if anything's been updated, but he could possibly be wanted out of Arkansas. I couldn't see for what. The last comment on that was November 7th, 2022. And then he has history in New Mexico for an aggravated first DWI in 2014, unknown dispo. And then he has a DWI in what I believe is Colorado in 2022. I'm not sure if that's pending or not. So given his history, the facts in this case, Judge, we would oppose a PR bond.
All right, I'm showing something about him going into federal custody. Did you see that on your criminal history?
I did not see that.
Okay, I'm showing something. He went into a federal detention center back in when he pled to the resisting in 2015. Does anybody know what that federal detention facility was?
I don't, Your Honor.
Not at this time, Judge.
Right. And I'm seeing the history out of state too. Colorado and New Mexico, is that what you're showing?
Yes.
And Washington? Yep.
I actually thought I saw a wanted out of Arkansas. I don't recall.
I'm seeing Washington, Moses Lake Police Department in 2017. That was just a criminal trespass back then. All right, I'm not seeing Arkansas. I'm not. Doesn't mean it's not here. I'm trying to peruse through what the bailiff gave me.
Permission to speak, Your Honor.
No,
Go ahead, Mrs. Elizalde, before I.
Sorry, Judge, I was just looking at the rap sheet to see. It's just a federal detention center of El Paso. I don't think he was actually in federal custody.
I don't know, Judge, for a fact, but I don't think that ever happened. I've represented him in the past. I've never seen him in federal custody.
Correct.
I just wanted to.
No, that's fine. I will say though that I see it twice, but it was all from that 2015 time. Because he had a resisting and an assault family violence. So I see it twice. But again, it was out of the same offense, the same time period.
I have a wanted confirmed. That one is still outstanding. Agency Police Department Cordova for failure to appear at a pre-trial. Yeah.
All right. All right, Mr. Gonzalez, I know that you're a zealous advocate for your client. My concern is the 15 was not what I was expecting when he had 2 charges. And so that concerns me. The other thing that concerns me is if he is able to post the 15, there are no PR bond components, okay? So what I'm gonna go ahead and do is, I hope you see it as splitting the baby a little bit, Mr. Gonzalez. I'm gonna go ahead and, what I'm gonna do is I'm gonna bring down the bond to 12,500. but I'm adding a 5,000 PR bond component. Okay?
Yes,
As
ma'am.
part of that PR bond component, to be ready in case he gets released, I want weekly reporting, regular restrictions and reporting, weekly reporting, curfew 6 to 6.
You told me to go through all of them.
Maruf, who was
Yeah.
that?
The annex.
The annex, okay.
Yeah.
You told me to go based off of.
Curfew 6 to
I'm
6.
sorry. Okay, curfew 66.
Yes. There's not an alleged victim, but I am requesting he give sample of urine upon request, not leave El Paso County without permission, not commit a new criminal offense, shall report his place of residence, shall not possess weapons or ammo, and shall abide by none of these he's on probation, correct? Correct,
That-
Mr.
that-
Like he's not on probation for anything right now.
He is not, Judge.
All right. And with that sample, giving a sample, it's also to not use any illegal drug or alcohol. All right.
Yes.
Mr. Gonzalez, I know that it is not what you wanted, but his criminal history spoke louder than your gracious words.
Thank you, Judge. Thank you for your consideration. Appreciate it.
Thank you. All right, we are adjourned on this matter. Thank you, Mr. Estrada.
And next, may we have Ibarra, Christopher Ibarra. In cause number 2022-0D0-5215 and 2022-0D0-5411, State of Texas versus Christopher Noe Ibarra. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Good afternoon, Judge Mark Rosales on behalf of Mr. Ibarra. We're also ready.
All right, good afternoon. And Mr. Rosales, just for the record, you do see your client on Zoom today.
I do, but I'm gonna go off of some information. I had a funeral plan for today that was moved because of Ash Wednesday. So we have not met prior to right now. So I have a lot of information ready to go, but we didn't meet prior to this hearing today.
Okay. So it is your motion though. Do you know
It
how
is.
much the bond amount is?
I do. There's on the case ending in 5215, the aggravated assault. That's $40,000. On the case ending in 5411, smuggling of persons, the bond is 5,000.
All right. So what do you know? What do you know anything about Mr. Ibarra? I mean, I can
I do.
reset you. I can
No,
reset
no.
you.
No, I can't get reset. Mr. Ibarra's been in custody, I believe, for approximately 39 days.
30, yeah,
Yes.
about 35 at least, yes.
Correct.
Okay, go ahead.
So he lives in Socorro, Texas. The last address I have for him is 10161 Aldrin Circle. His phone number is 575-590-2726. He'll be residing there. He was gainfully employed here prior to being arrested. He has 2 children that are his dependents. He has a vehicle of little value, no offense, sir, but it's a 2004 Chevy Tahoe that really won't support any kind of collateral for a $40,000 bond. So he doesn't have that kind of collateral, even if he were to be able to obtain the $4,000 to get into a bonding company. The aggravated assault, by all accounts, is a fight. What is making a fist fight, what I believe is the aggravating factor, is he's accused of using brass knuckles. There is no serious bodily injury alleged in what I have seen. There appears to be photos of maybe scrapes and cuts to the alleged victim, but there is no serious bodily injury that I see alleged in the case. I other than the cases before the court, I don't see much other history, but that may be on my end that I don't have privy to all of that. Nevertheless, Mr. Ibarra is about 21, 22 years of age. He had been employed. I think this was more of a fight between, I don't know the correct terminology, but it's not him out there trying to use a weapon like a gun or a knife or something of that sort. The smuggling of, that's on the aggravated assault. So I think that at least could warrant perhaps a reduction to either PR or maybe a $5,000 split bond. On the smuggling offense, Your Honor, the allegations are that he is the passenger in a vehicle driven by someone else who is transporting people here that are in the United States without resident status. The allegations are that he is the person that's supposed to get a call from someone to say where they're supposed to go. There's no allegations of weapons. There's no allegations of harm. There's no allegations of any kind of violence to anyone. And that's that case. But importantly is that one of the offenses was a non-arrest case. And I think that's important to the court to point out that he didn't flee the jurisdiction. He knew he was being looked into, knew an offense potentially had been committed, didn't flee. When arrested, he was taken in without incident. So he really has nowhere else to go other than here in El Paso. I don't think he's a flight risk. And for those reasons, we asked for a bond reduction.
All right, State.
I'm going to go ahead and move forward on the aggravated assault. Mr. Preston is covering the bond hearing as regards to BPU, the smuggling case. I would not surprisingly disagree with the characterization of the incident. Unfortunately, Judge, I think it's important that you know what transpired and what led to this incident. So officers were dispatched in reference to an assault and a stolen cell phone. CW stated he was seeing the defendant's ex-girlfriend. He received a message from her that the defendant was using her phone to talk, and I apologize, to talk shit to him. Received a message asking if she could go to his house. CW said yes and gave a description of a house. The CW saw the defendant driving.
I think you might need to slow down.
Okay.
Yeah,
Okay, give me like one.
no problem. We'll resume when Ms. Wright is available.
Oh,
Yep.
okay.
All right, she's ready. Go ahead.
He then saw him hiding between his neighbor's rock wall and food truck. So he laid in wait for the CW. CW got out of his vehicle because he thought the defendant was going to damage his car. The defendant then rushed at him and assaulted him with brass knuckles. Defendant's friend was also there, and they both began to assault him, both with brass knuckles. The neighbor tried to separate them, but they kept kicking him. Eventually, they ran off. The neighbor lent him his phone. He called his phone. The defendant answered and said, "Come get your phone." So there's nothing about got together to fight. This is not, what is alleged. Also, he has, I think there's something to indicate that there wasn't serious bodily injury. Not that I would have to prove that in this case, but I will say that we've had contact with CW that he has had to get staples. He went to the hospital and had to get staples.
It's not alleged SBI. It's alleged deadly weapon.
I just wanted to make sure that was on the record. And then we have a history. He's got juvenile history, including an assault bodily injury in 2018 that he pled true, and then assault family violence in 21 that he's dismissed. In addition, he has a BPU case that I'm sure Mr. Munson will speak on, but the rec on that is 2 TDC, which I believe will also make him a flight risk. And so I would ask the court to consider that as well. Your Honor, these facts are extremely concerning. And I would also say that there is no change in circumstances that would warrant a change in bond, and further say that bond was reasonable when it was set, and we would object to any reduction.
Okay, Mr. Munson, on the smuggling, what do you have to say?
Yes, Your Honor. We believe for the smuggling case, as Mr. Rosales stated, it's a $5,000 bond. I think that's pretty reasonable considering they were transporting 5 individuals in this case that were undocumented non-citizens. The alleged statement where Mr. Ibarra gave that he stated that he was in contact with a person that they call a cholo that's out of Juarez, Mexico, who's the one that's kind of giving them directions on where to drop off the individuals.
Was he the passenger?
He was the passenger.
All right, so that explains the 5,000 on that, because it's
Yes,
5
ma'am.
counts,
Right.
correct? It's 5 counts on the smuggling? And it's 5,000 total, not 5,000 for each count, correct?
Yes, I believe it's 5,000 total.
All right, so now I understand that bond. All right. All right, Mr. Rosales, his criminal history does concern me, but I also do realize he's 21. And, but I am not going to a full PR bond.
Fair enough.
I won't do that. And I'm also probably am not lowering it as much as you would like, okay? But I do recognize that he's on $5,000 PR, I'm sorry, he's on $5,000 bond for 5 counts. But then he's on 40 for 1 count, second degree. All right,
Correct, Judge.
so what I'm gonna go ahead and do is on the 40,000, I'm going to lower that to 25,000 cash and 15 PR, okay? As part of those PR components, I want weekly reporting, curfew from 6 to 6, samples and not using illegal drugs or alcohol, not leaving El Paso without permission, not committing a new criminal offense. Shall report place of residence to PR and not move, shall not possess weapons or ammo. And that is it on the bond for the ag assault. On the 5,000 for the smuggling, Mr. Rosales, I'm not going to touch that one, okay? It's barely 1,000 per person, okay?
I understand, Judge, and it just that, you know, I was listening earlier, the first degree felony had a $12,500 bond, and I thought, you know, that's why I was shooting for the $10,000 bond, because it's a second degree.
I know, and when that 12,500 came up, I was really surprised by that, if you remember what I said.
I do remember, Judge, and
I was
that's why I was shooting for a $10,000 bond, something similar.
Well, you're on 5,000.
Well, on that one, that's true, but not on the other one. But
Oh.
that's fine.
I see what you're saying.
Yeah.
Judge, really quickly, I wanted to ask you a question. Maybe I missed it. Did you have no contact to the aggravated assault with the deadly weapon because he was?
You know what? I did not. Let me add that. No contact with the CW or or the ex-girlfriend.
Of course, Judge, we have no problem with that.
Yeah. Well, let me say this. You can always re-urge your motion at a later time, Mr. Rosales, if he's still not able to meet it, okay?
Thank you, Judge.
You get more bites at the apples on this ones. All right?
All right.
All right.
Thank you very much.
Thank you, Mr. Rosales. Yes, we are adjourned on this matter.
Okay.
All right.
Staying on page 18, Judge. Annex, may we have Marquez, Ruben Marquez.
Yes, sir, coming right up. Ruben Marcos. Yes.
In cause number 2022-0D0-1055, State of Texas versus Ruben Marquez Jr. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
And Daniel Avalar for Ruben Marquez.
All right. Mr. Avalar, do you see your client on the Zoom today?
Yes, ma'am, I do.
All right. Mr. Marcus, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you may lower your hand. Mr. Marcus, are you waiving your right to an in-person hearing, and are you okay proceeding with this hearing through Zoom or teleconference?
Yes.
All right. With that being said, please state your name, date of birth, and whether or not you are a U.S. citizen.
Marcus 3761, born in the United States, El Paso, Texas.
All right. Thank you, Mr. Marcus. Let me let
Sorry,
you.
I didn't hear the first name. Did you say the first name?
Yes. Ruben Marcus.
Thank you.
Mr. Marcus, you are charged with DWI third or more. It is a third-degree felony, looking at a punishment no less than 2, not more than 10, and a fine not to exceed $10,000. Do you understand these charges?
Yes, I do.
All right. Do you understand that as you stand there, you have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, or a right to call witnesses on your behalf or in your defense?
Yes.
All right. Mr. Avalar, have you had more than 10 days to prepare for the defense in this case?
Yes, ma'am, I have.
All right. Mr. Marcus, I've been handed what's been marked as State's Exhibit 1, which are the plea papers and the said cause number. Did you sign these paperwork? I'm going to try to show it to you right there. Can you see it?
Yes, ma'am, I do.
Okay. These are your signatures?
Yes,
And did you read and understand the plea papers?
yes,
All right. Mr. Avalar, did you explain the plea papers to your client, and do you believe he has understood the admonishments, the rights, and consequences of giving up these rights by entering a plea in this case?
Yes, ma'am.
Mr. Marcus, are you satisfied with your attorney's representation of you in this case?
yes, ma'am.
All right. And Mr. Avalar, do you have any reason to believe your client is not competent to enter this plea?
No, Your Honor.
All right. Mr. Marcus, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
No, Your Honor.
All right. Based on your testimony, your attorney's representation, and my observations, I find that you are competent to enter into this plea. You've stated that you are a U.S. citizen, and while I truly believe you, I need you to understand if you aren't for any reason, a plea of guilty and a finding of guilt may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, Your Honor.
All right. To the charge against you, the DWI third on a third degree, what do you plead?
Guilty.
And are you doing so freely and voluntarily?
Yes.
All right. State, would you please summarize the evidence?
Yes, Your Honor. Had the state proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 9th day of March, 2022, in anterior to the presentment of this indictment in the county of El Paso and state of Texas, Ruben Marquez Jr., hereinafter referred to as defendant, did then and there operate a motor vehicle in a public space while the said defendant was intoxicated. And it is further presented in and to said court that prior to the commission of the aforesaid offense, hereinafter styled the primary offense, on the 23rd day of May 1991, in cause number 900C13085, in the County Court 1 of El Paso County, Texas, the defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated. And on the 14th day of August 1998, in cause number 980C07791, in the County Court 2 of El Paso County, Texas, the defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated. And on the 12th day of February 2004, in cause number 2003-0D06103, in the 409 District Court of El Paso, Texas, the defendant was convicted of offense related to operating of a motor vehicle while intoxicated. Your Honor, there are 2 enhancement paragraphs related to convictions that became final. However, we are not proceeding with the enhancements as he is only doing a TDC.
Okay, so he is pleading to a third degree, correct?
Right.
All right. I have some papers in front of me, Ms. Elizalde.
Yes, Judge. Sorry. First, I would ask that the state's exhibit number 1 and state's exhibit number 2, that being the plea papers and the disclosure form, be introduced into the record.
Mr. Avalar?
No objection, Your Honor.
All right. Is there a plea bargain agreement, Ms. Elizalde?
Yes, Your Honor. The state's recommendation is 8 years confinement in the Texas Department of Criminal Justice with no period of community supervision.
All right. Mr. Avalar, is this the plea agreement?
Yes, ma'am, it is.
Have you had a chance to review portal and all documents tendered to you?
Yes, ma'am, I have.
All right. Mr. Marcus, is this your understanding of the plea agreement?
Yes, it is.
All right. Understand that the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court finds the plea, if the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled ruled upon before trial or by permission of the court. These are the appeal rights explained in the trial court's certification of your right to appeal. The original of which was signed by you, your lawyer, and by Judge Bettis and by me, and which will be provided to you at a later time. Based on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I find you guilty of the offense of driving while intoxicated, third or more. I assess your punishment at 8 years in the institutional division of the Texas Department of Criminal Justice. There is no fine. Your sentence will commence this day and you will be given credit for any time that you have spent in jail on these charges. I am assuming from the facts that there was not an accident, so I'm assuming there is not a victim impact statement. Is that correct, Ms. Elizalde?
Correct, no victim impact statement.
All right, anything else from the state?
Nothing further.
Anything else from the defense?
No, Your Honor, thank you.
Did I follow the plea agreement?
You did, and we appreciate it.
All right, Mr. Marcus, I wish you the best. I need you to go ahead and you'll be fingerprinted in just a little bit by the people at the detention facility, okay?
Okay.
Good luck. Godspeed, Mr. Marcus.
Thanks.
We are adjourned on this matter. Next, Mr. Marufo.
Then on page 18, Judge. Annex, may we have Eddie Morris?
All right.
Good afternoon, Your Honor.
Good afternoon, Miss Elise. How are you?
I'm good, and you?
Good, good. All right.
Any more?
Mr. Marufo, you can call the case.
In cause number 2018-0D0-1845, State of Texas versus Eddie Morris. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
Araceli Solis on behalf of Mr. Morris, Your Honor, we're ready.
All right. My understanding is we are here for a probation status. Is that correct?
It's correct, Your Honor. We also filed a motion to set bond back on, I believe, February the 9th.
Okay, that's not what's showing up on my docket, Miss Elise. Let me ask Miss Elizalde if she was aware of that motion.
Judge, I was aware of the motion back then. I was not aware that they were going to try to address bond because it's just a probation status hearing today.
Yeah, that's what I thought.
Well, only just because he's detained and we were scheduled for a hearing, I believe, last week, and there was a conflict, so it was reset for today. So my understanding was I was going to be able to address the bond as well, Judge.
Remind me, Miss Elise, I felt like I covered that hearing last week. Remind me just a little bit.
No, Your Honor, I actually had the conflict in the court, went ahead and allowed me the date for today, Judge.
Okay, and did you and I speak at all last week?
No, Your Honor.
Okay, all right.
Judge?
Yes.
It's Mirna, if I may interrupt for a second.
Yes.
Ms. Solis's office last week stated they weren't ready for the bond hearing, that they would just want to address the probation status. So the bond hearing wasn't reset.
Okay, okay, I apologize. That was my understanding. I was trying to get a copy of the motion revoked, which I believe was barely entered today.
Well, let me say this. I know we don't have jail time on Thursday, but I know that there's time on Thursday if you want to have the bond hearing. Well, but see, it's not even 3 days. Ms. Elizalde is still going to end up having to waive.
Judge, I will waive my 3 days.
I'm sorry, say it again.
I'll waive my 3 days if the court wants to move forward today.
Move forward today. You're okay? All right. So then let us go forward on both the probation status and then the bond. Go ahead and tell me what the bond amount is right now, Ms. Solis.
My understanding is there is no bond, Judge.
Okay. All right. So then go ahead and tell me what you know about Mr. Morris, Ms. Solis.
Yes, Your Honor. My client's 37 years old. If he's able to make bond, he will be residing at 3220 Slocum here in El Paso, Texas. I did speak with Miss Marisol Revolta, and she is the one who's willing to assist him. He indicated to my investigator that he is working 2 jobs. He's been working at Albertsons and Taco Bell. I did try to reach out to his probation officer, which I believe was David Bruce, but I haven't been able to speak with him. He's been in custody since February the 4th. My understanding is he was placed on a 10 years probation back on October the 30th of 2018, Judge. Your Honor, I'm appointed on this case, my client doesn't have a lot of funds for bond. As I mentioned, his friend is willing to help him out. However, only if the court would respectfully request that the court would allow him a PR with a small cash surety component, Judge.
All right. He was on probation in 2018 for 10 years. So what gets him picked up and put in jail? What exactly? Because I'm not showing a new offense right now.
No, Your Honor, I don't believe there is a new offense. I believe it might have been a non-reporting, Your Honor.
For how long, do you know?
Your Honor, from looking at what I researched, I found that this affidavit was filed, I guess, on November the 1st of 2022. But as I mentioned, I had reached out to Ms. Elizalde to see if we could get some type of probation information. I know she was unable to provide that. So I tried to reach out to Mr. Bruce as well. However, I wasn't able to get any more information as far as what he was lacking in regards to the probation.
All right. I have present for the hearing Ms. Carla Pineda with Court Services for the Probation Department. Let me have Ms. Pineda tell me what she knows about Mr. Morris and his compliance with the probation.
Your Honor, Mr. Morris last reported to the Probation Department July 20th, 2022. Thereafter, August 2022 through January 2023, he failed to report. There is notation, Your Honor, that probation did try to reach out to him to have him report. He just didn't report. He was there. I'm sorry.
Any new offenses?
There's no new offenses, Judge.
Okay, but the
Just
failure
failure to report.
Okay. Anything else I need to know about him?
The MTR was filed today, Judge, effective today. All he has pending are his community service hours, probation fees. He was assessed at one point with EHN, but since he stopped reporting, we don't know if he's been receiving services. And there is notation that previously back in 2018, Your Honor, there was also history of failure to report where the MTR was filed back then. It was dismissed. He did a 30-day jail commitment. In addition to that.
Wait, when was that?
That was back, the case, the failure to report, Judge, was December 2018.
So right after he gets put on probation, he doesn't report. He gets put in jail for 30 days. And then he does well for a few years, but then he stops in July.
Well, thereafter, Your Honor, on October 9, 2019, there's also notation that he was rearrested for an assault, family violence at the time.
Doesn't work.
There was a second MTR filed. It was dismissed, and Mr. Morris was at one point, Judge, January 2020, was transferred to the 384th Competency Court.
I'm going to assume.
Wait. Hey, I'm sorry. Can you mute the next? It was transferred to 384th.
January 2020, he was transferred to the 384th Competency Court. At that point, that's where the MTR at that point was dismissed. Moving on to February 28, 2020, the status hearing was held. The court agreed that he would continue with MHI services. He was referred to HN at that time and started reporting. Since then, that's when Mr. Morris did complete BIP. He paid off his court cost fine. He paid off restitution and reported from February 2020 through July 22. And then that's when we're back to the failure to report from August 2022 through January 2023.
Right. All right, Ms. Elise, this is an individual who's not been doing well on probation. All right. I understand he has no bond, and so I have to give you some numbers, okay? And so what I'm looking at is I'm looking at a 60,000 cash surety, 10,000 PR. As part of that PR, I want him weekly reporting, curfew 6 to 6. Give a sample upon request and not use any illegal drug or alcohol, not leave El Paso County without permission, not commit any new offenses. Shall report his place of residence to PR and not move, not possess weapons or ammo. And then I'm going to go ahead and just to be safe, since we talked about this a little bit, he shall abide by all medical, psychiatric, and psychological care and treatment as prescribed by OCR/EHN. All right, since that was an issue in the past, I want to go ahead and add that here. Mr. Morris, I gave you a $60,000 cash surety bond and a 10,000 PR. I'm not sure if you're going to be able to make it. If you do, you need to comply with the terms of PR bond. Okay. If you do not comply with the terms of PR bond, we will revoke the bond and you will be put back in jail. Okay. I debated about even giving you a bond amount, but the law says that I must, especially when you had a no bond. All right. In the past, you have not fulfilled the terms and conditions of probation well. I need you to change that starting today. All right. Are you in agreement? All right. I'm not having a sound from the annex because they muted, but I'm seeing a shaking of the head.
Yes, Your Honor, and then I'll go meet with Mr. Morris so I can explain everything again.
All right.
Okay.
He must report
Yes,
above
sir.
all things. He must report. Ms. Pineda, did you have something further?
Yes, I apologize for the interruption. On the record, if I may, just if he does meet his PR bond, if we may also remind him that he is to also continue on probation and contact Mr. Bruce as probation officer.
That is true. In fact, the last one shall be abide by all terms and conditions of the probation in this clause number, which is 2018-0D01845. Thank you, Ms. Pineda. All right. So everything that you still had to do on probation, you still have to do if you get out on PR bond, okay?
Yes.
All right. Thank you, Mr. Morris. We're adjourned on this matter. Ms. Solis, thank you for your patience.
Thank you, Your Honor. Maybe
You're
excuse
free.
me.
Yes, you're free to go if you have nothing further. Mr.
Thank you,
Marco,
Mr.
who do we
Gonzalez.
have next?
Then on page 18, Judge, annex, we have Mejia, Mario Mejia.
Yes, sir. Yeah, Mario?
In cause number 2013-0D03853, State of Texas versus Mario Miguel Mejia. Announcement of council, please.
Adriana Elizalde for the state. State is ready.
Who's here for defense? Is it Mr. Huffman?
Mr. Hoffman, Judge.
Good afternoon, Your Honor. I'm sorry, Judge. I was under the impression that 95 has subbed in.
I'm showing you, Mr. Huffman. If you've gotten an order to substitute, let me know, but I'm showing you right now.
Monica Lerma, job probation, Your Honor.
Thank you. Mr. Huffman, do you have an order from somebody else substituting you out?
I don't know if the court has signed it, Judge, but there's been one filed.
Let me look. Give me a second. Give me a second.
Yeah, I am still showing the PD's office.
Motion to substitute counsel filed the 13th. Give me a second.
I don't think I see an order, Judge.
Well, let me
That's
see.
a signed order from the court.
Okay, motion to substitute counsel. For some reason, it's. Give me a second. I'm not sure if I'm going to be able to have access to see it. Grant permission to withdraw. Mr. Pada has been retained. He does not oppose this. Did Mr. Pada sign off?
Judge, I signed off.
You signed off?
Mr. Butta filed the motion to substitute.
Okay, so then let us go ahead and reset this to go ahead and bring in Mr. Pada. Okay. Okay, are we sure the contract, well, not the contract, but we're sure Mr. Pada is going to be doing this, correct?
I'm sure, Judge, if probation is considering letting Mr. Mejia out, I'd rather not delay it and let Mr. Mejia out of jail.
No, I mean, he filed. I just want to make sure it was filed as of 2/13.
Well, yeah, I'm sure Manny's intends to do it, Judge.
Okay.
Maybe we can call Manny and get him here.
Do you want to wait? I'm
Oh,
going to be putting in a little bit, I'm going to be putting Ms. Montes and Mr. Acosta in a break room. Do you want to wait?
I could call Mr. Pada's office, Judge.
Okay, you're going to call Pada?
Sure.
Or you want Ms. Hernandez to call Pada?
I can do it, or whichever.
Let me have Ms. Hernandez call Pada.
Okay.
Okay, so Mr. Mejia, go ahead and have a seat. We're adjourned for a little bit. Mr. Marufo, where are we next? Can I?
Page 19, Judge.
Okay.
And next, we have Ortega, Nicolas Ortega.
Rick, you got this one?
Yes, ma'am.
Okay. It's going to take him a while, Marufo. Go ahead and start calling all the cases, please.
In cause number 2022-0D04728 and 2022-0D02461 and 2021-0D03088. State of Texas versus Nicolás Salvador Ortega. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Ortega, we are ready, Your Honor.
All right, so Mr. Huffman, this is set for a bond hearing. I'm making the assumption it is your motion. Will you please tell me the bond amounts, please?
Judge, Mr. Ortega is booked on 3 charges. An evading in a motor vehicle, that bond is $100,000.
This is my 450,000 that you didn't understand the math.
40,000 less than $500,000.
Yes. Okay, so you got 100,000 on your evading. You got
100,000 on the evading, 100,000 on the VPO within 12 months, 2 within 12 months. And then 260,000 on the aggravated robbery, injury to a child, and burglary. It's all under the same cause, consolidated.
All right. So tell me what you know about Mr. Ortega, Mr. Huffman.
Sure, Judge. Your Honor, Mr. Ortega is 34. He is a U.S. citizen. He has been living in El Paso since he was 3. Judge, his whole family lives here. Immediate family, extended family, pretty much everybody lives in the El Paso area. Your Honor, he has 5 children. The oldest being 6 years old, the youngest being a newborn, a few weeks old. Your Honor, Mr. Ortega is appointed, so he has been found by this court to be indigent. He currently works as a cook at Speaking Rock, as well as a barber. Your Honor, if released, Mr. Ortega would live with the mother of his newborn child. Your Honor, Mr. Ortega was out on bond, PR bond, before he was arrested on these new charges. It's my understanding that Mr. Ortega was reporting the PR bond and that he was basically appearing at court as required. The violation of protective order, Judge, is over 2 years old. And the allegations are that he sent the mother of his children an email. The evading arrest, judge, is I would characterize it as a standard evading. There were no accidents, no injuries. And Your Honor, on this case, the new case, admittedly, the charges read pretty badly, but this is one incident, Judge, and basically the incident started with a call from Mr. Ortega's niece, who is also a co-defendant, Your Honor. His niece is about 18 years old, and his niece called him and said, hey, my ex-boyfriend, who she was living with at the time, won't give me my stuff back. I need help to get my stuff back. So Mr. Ortega, along with his niece and his niece's cousin, another co-defendant, went to this ex's house where, like I said, his niece was living at the time to get her stuff back. There's I think some confusion about who pulled the gun out. Mr. Ortega has been consistent with me in saying that he didn't know there were any guns involved. The niece's boyfriend called 911, and on the 911 call, he says that the niece's cousin had the gun, the co-defendant Marcus. Also in Marcus's statement, he admits to being the one with the gun.
All right. Let me go ahead and hear from Ms. Elizalde.
Yes, Judge, thank you. Just a brief description on each, Judge. Stop me if you want me to move on. Now, on the one ending in 461, the defendant was speeding. Officer made contact with the defendant. Defendant had a warrant, refused to get out of the car, and he drove off while officers were trying to open the door. The defendant jumped over a curb and traveled between sidewalks and entrances of two apartment complexes where he was lost. Ultimately, he was found. Now we have pause number ending in 3088. Judge, this is for a continuous VPO violation, and it relates to emails, calling the victim names that I'm just not going to go over here unless the court wants.
No, that's fine. My understanding is he was on bond for this one and it was revoked because he picked up the new offenses, correct?
Yes.
All right.
And we have yes, Judge.
So go ahead and take me to, I guess what I'm concerned about is where it becomes the ag robbery and the injury to a child. Explain to me those really fast.
Okay, so it's actually an injury to an elderly. I apologize for this. So that it's a child or elderly. Officers were dispatched to a subject with a gun. The CW was at home and she saw multiple people outside. CW refused to open the door. Subjects broke down the door. There was two males and a female. They entered the home and demanded to know where her grandson was at. Now Marcus and Nicholas, defendants threatened to kill the victim. Both of them did. Defendant displayed the weapon. It is true that the co-defendant tried to take the rap, but from the police reports, at least, it seems that it was Mr. Ortega, or so the victim identified. The defendant pointed the gun at the victim in order to move. The victim feared for her life and thought they would kill her grandson. During the incident, they stole some shoes. So they didn't just go to pick up her stuff. And if I recall correctly, Marcus, the co-defendant admitted that they were going in there with the intent to kill Jesse, but Mr. Marcus, who was making the statements, also said that it was Mr. Ortega who broke down the door.
Okay, go ahead.
The history, just promptly, Judge.
No, I have the history. I have, my bailiff provides me with the history. So I have, it's a long history.
Yes.
And in fact, I believe I'm showing that at one point he did go to Huntsville.
Yes, he has a trip. The rec is 7 TDC. Judge, I mean, all of the charges are concerning. Already, we have an alleged violation of protection order. That's already a demonstration of complete disregard for court orders. We ask that you take into consideration that the recommendation is 7 TDC. We consider him a flight risk. He is not probation eligible, and his history, as you see before you, he has multiple evidence of that. Probation revoked in many of his cases. So we would object to a bond modification. We think he picked up a new charge. There's nothing that would warrant a reduction at this time.
Another new charge?
Well, no, that I'm talking about the Burghab that he picked up. So nothing has changed in the ways of reducing the bond is the state's position at this time.
And Judge, if I could just briefly respond to that. It's a couple of the comments from Ms. Elizalde. Briefly, Your Honor.
Yes, I wasn't saying no. Sorry,
Thank
I
you,
guess.
Judge.
Sorry, yes.
Your
go
Honor,
ahead.
I think Ms. Elizalde had mentioned that the complaining witness feared for her life or something like that. I just kind of wanted to point out, Judge, that the complaining witness was outside with these with Mr. Ortega and the two co-defendants when the police arrived. She was outside. She was outside of the house on the phone with the police with them. So it's just kind of hard for me to believe that she was so afraid for her life, but yet she wasn't inside the house. She was literally outside waiting for the police while they were still there. About Mr. Ortega's criminal history, Judge, there's been no convictions for any violent history. None. There was a prior pen trip over 10 years ago for 2 years for a true DWI third. And Judge, I think it was probably should have been more like a second, because Mr. Ortega's first DWI was is not alcoholic. It was all the allegation was that he was, I guess, high on marijuana. So I'm thinking that probably should have been fought, Judge, but that's there's no criminal, like I said, there are no criminal convictions, Your Honor.
All right, this is the thing, and I understand your position, Ms. Elizalde, but the point of the matter is he's at almost $500,000. So it is quite a bit. And I understand I have a victim that I'm concerned about. But the 260, the 100 and the 100 are just a little too much. Mr. Huffman, it doesn't mean that I can guarantee he's going to be getting out, okay? Because I am not by any means going full PR. He is a danger to community. So these are my new bonds. I'm going to 150,000 for cause number 4728, 150,000 cash surety. And I'm going to do a 50 PR on that one. For 2461, I'm going to 75,000 cash surety with a 25 PR.
Your Honor, may I say something? I apologize for interrupting.
Judge, just for the record, Judge, I would like to advise Ms. Ortega not to say anything at this point, Judge.
Mr. Ortega, your attorney has spoken and would like for you not to speak.
I just wanted to clear this up, certain things that Ms. Elizalde stated that I stole some shoes.
And again, Judge, for the record, whatever statement he's about to make is strongly against the advice of counsel, Judge.
Mr. Ortega, he's asking you not to speak.
Yes, Your Honor, okay.
I understand that okay, let me go ahead and explain to you. I understand my ruling is not going to be something that's beneficial to you at this point.
Okay.
But I need to go ahead and bring it down from the 460,000 that it is at.
Okay.
All right. As the case develops, he can re-urge this motion and see if I or Judge Pettis will lower it in the future. Okay. But right now you're at 460,000. I'm bringing you down to a total of 300,000. Okay.
Yes, Your Honor.
All right, I understand it's not what you want, but you and your attorney can speak, okay?
Yes.
Later on in person, okay?
Okay.
So going back on 3088, that's the 2021, also a 70,000 cash surety, 25,000 PR. All right. So with those PR bonds, I want monthly reporting, curfew 6 to 6, not come within 200 feet of any of the alleged victims, sample of urine, and no consumption of illegal drugs or alcohol, shall not leave without permission, shall not commit any new offenses, shall report the place of residence to PR and shall not move without permission, shall not possess weapons or ammo, and all terms are concurrent. So I brought you down to 300,000, Mr. Huffman. So let's see where you're at. He's been in jail. I'm showing about 3 or 4 months right now, 3-4 months. I'm showing that you are set for trial. I had that a second ago. Anyone who can give me the date is highly welcome to do so.
Judge, I'm thinking in June.
Okay.
June or July.
May?
I see a jury trial 6/16 on 3088. I'm not sure if that's the one.
Okay, thank you so much, Ms. Wright. I appreciate you giving me 6/16/23 is correct. There is a jury trial. And hopefully you all can reach a resolution, okay? All right, Mr. Ortega, keep in touch with your attorney and you can speak to him and tell him your disappointment, okay? But let's not do it on the record, okay?
That's fine.
All right, good luck, Mr. Ortega. This hearing is adjourned. Mr. Marufo, I feel like I'm behind schedule here. Mr. Parra, let's go real fast to Mr. Mejia.
Yes, Your Honor.
If the annex can put Mr. Mejia back on. Mr. Parra, we did not know that you were substituting in, is that correct?
That is correct, Your Honor. I'm showing that the motion was filed on the 13th, but I wasn't aware that we hadn't had an order signed.
Okay, I'll go ahead and sign that order. Ms. Hernandez will bring it to me and I'll go ahead and sign it, but you are taking over for sure, correct?
That is correct, Judge. Just meant.
All right, we were just set for a probation status today. And so Miss Leal Miss Lerma is here. Miss Lerma is here for probation. And she can go ahead and tell you how he was while he was on probation.
Good afternoon. Mario Mejia was placed on probation on June 3rd, 2014 for a period of 10 years, deferred for the offense of sexual assault of a child. His probation will expire June 2nd of 2024. Initially, he was referred to a treatment program on June 7th of 2014. He was subsequently dropped from that particular provider in April 2018, and then re-referred to a new provider for this particular treatment program in December of 2018. His biggest problem is that he wasn't showing up to this treatment program. Yeah, this went on for years. He hasn't gotten very far. Should he remain on probation, we will need to extend him at least 2 years so that he can complete this treatment program. As far as community service goes, out of 200 hours of community service ordered, he completed 93.5 of those hours, leaving him with a balance of 106.5 hours. He does have large outstanding balances. I understand that financial issues were Mr. Mejia's biggest problems in the past and presently. We're willing to work with that. However, he needs to really get back into this program so that he can complete his probation. As far as reporting, that hasn't been too much of an issue. No drug use. However, he needs to complete those UAs when he is instructed to do so. on a more regular basis.
Okay. And what we're hoping for, Your Honor, is that we can secure his release as soon as possible to allow for compliance and to allow in completion of that program, Judge. I'm not sure if that's something we'd be able to address today.
Ms. Elizalde, what's your position really fast?
Judge, on this one, I didn't look at history, criminal record. I'm not prepared today. I'm not waiving it on this one just because it was never set before.
Right,
As
it
a-
was just it's a probation status, Mr. Pata. It's not,
is,
it's not-
I
it's
understand.
not the bond hearing, and I understand she has actually waived either 2 or 3 today. But due to the nature of this case, I do understand her not waiving, and I respect that completely. So do you want to file your motion for bond and have it set possibly next week, Mr. Pata?
Yes, Your Honor. In the meantime, I'll continue in communication with Ms. Elizalde to see if we can reach some kind of an agreement before then.
Yeah, that would be nice. And again, she's waived, you just kind of came on, you haven't seen, she's actually waived, I believe she's waived 3 today. Due to not being listed as bond. So I'm appreciative of that, and I do respect her not being able to waive this one.
Thank you, Judge.
All right. All right, Mr. Pata. So then, Mr. Mejia, keep in touch with your attorney, who is now Mr. Pata. I have signed all the paperwork. It was brought to me a second ago. Stay in contact with him. We'll see you next week, okay?
Thank you.
Thank
Okay,
you.
sir. Yeah, thank you, sir.
Thank you, Mr. Pata, for your understanding and for zooming in so fast. I do appreciate that.
Like the
Okay.
pun, Judge.
Take
Okay.
care. Ms. Lerma, we are concluded with this matter unless you have something further.
Nothing, Your Honor. Thank you.